Coulson Elder Law in St. Louis, Missouri and O'Fallon, Illinois, and this is your Elder Law and Estate Planning Minute. Today I want to talk about sort of an unpleasant subject, and that is the question of, can I disinherit my spouse in my will? Quick answer to that question is no, because as long as you are married at the time of your death, if you don't leave anything to your spouse, there is a state law. I know it's in effect in Illinois and Missouri. I think it's in effect pretty much everywhere, that gives that surviving spouse the right to what's called take against the will, to get, if there are children, a third; if there aren't children, half of the estate, regardless of what the will says. So I guess that sort of raises the question, well, why would somebody want to disinherit their spouse? If they don't love them anymore, why don't they just go ahead and get a divorce? Well, in some cases, for religious reasons, they don't want to consider that as an option. In some situations, they've grown apart and live apart, but just have still stayed married. But by far the most common situation is the one in which the spouse who would be disinherited is in a nursing home and on or going to apply for Medicaid. If they received an inheritance, you might as well say you were giving the money to the state, because that's where it would wind up going and not to them. You still can't do it, but in that instance, and this is another topic, there's a special type of planning that we can do to provide for that spouse in a nursing home without causing them to lose eligibility for Medicaid. So the good news there is that you don't have to do something that you really wouldn't want to do, but thought you might need to do, but it wouldn't work if you did it. I hope that clears things up, right? Thanks.